So our challenge going forward is to not screw up this amazing gift that we got out of Heller. It is to maximize Heller's potential going forward by bringing the right cases with the right people at the right places at the right times in a thoughtful manner so that we can win as many of these things as possible. I caution you, there is no constitutional provision these days which is perfectly interpreted. It is naive and unrealistic for us to expect that the Supreme Court will suddenly find perfection in the Second Amendment where it has eluded them although these many years in the other parts of the Constitution. And in fact, I doubt very much that there's a single member of the Supreme Court, past, present, or future, who would tell you that every single one of their decisions is correct. Of course, nobody believes that, so steel yourselves. We're not going to be batting 1,000, but we can definitely do a lot better than many people would give us a hope for. I think actually we're going to do quite well so long as we do the right things. Let me tell you from my experience how it is that we should be going forward and what we can do to improve the way that the Second Amendment community deals with litigation. So let's go over what works and what does not work and what the opportunities and challenges are going forward in litigating the Second Amendment. The single biggest immediate threat to our gun rights is not the appointment, believe it or not, of hostile judges, although that is a problem. But it's a problem that's going to take time to manifest itself. It's a problem that's going to take time to develop. The problem that we have is also not necessarily anti-gun groups. They're always going to be around. Frankly, I'm not super impressed by the things that they do. And of course, most usefully, they are wrong. And so that limits their ability to be effective. The single biggest threat that we have to our firearms freedoms is rash and unwise litigation, ostensibly from our side, done by people who frankly do not know what they are doing and have no business doing it. This is why lawyers specialize. All I know about most areas of law is that I'm ignorant in them, and so I leave them alone. I stick to what it is I know how to do, and I leave the rest to other people. Civil rights litigation, and in particular, strategic civil rights litigation, is a specialty too. It's not something that anyone can do well, but there are also people out there who do stuff that could be done a little bit better. And usually, the deficiency is because there's a failure to understand, and this is a commonly shared misconception, there's a failure to understand that litigation is not lobbying. It is not politics by another name. It is a different, a fundamentally different art. In Chicago, I chose Otis McDonald as our lead plaintiff. Now, how many people here have seen anything out there about Otis McDonald? What an amazing fellow this guy is. I mean, I've never met anyone as magnetic and charming and just plain endearing as this poor 76-year-old man on the south side of Chicago, a guy who's been working hard all his life. He's always struggled for what's right, and he just wants to have a gun to defend himself. I think Otis was a fantastic person to tell our story. That's why I made him our lead plaintiff. The NRA chose itself. Now, believe me, I love gun rights groups who pay my bills and put food on the family, but as my good friend and patron Alan Gottlieb would say, we care about the faith, not the denomination. Unless there is some really good reason to do so, I will not put a group as a lead plaintiff. It absolutely never occurred to me to do so in Chicago, to make a case of SAF versus Chicago. It simply did not enter at least my way of thinking. Now, because politics is a democratic process, everyone can co-sponsor everything, right? It's easy to take credit for all the good things that happen up on Capitol Hill or wherever. Litigation, on the other hand, is done by parties who are who, for better or worse, are driving the process. In Congress, you can have omnibus bills, right, running thousands and thousands of pages that no sane person would ever care to understand, right? Courts don't have that kind of attention span. So I file cases that deal with maybe one or two basic issues tops. Cases that challenge lots and lots and lots of different things are going to be a lot tougher. There's also a natural tension between lobbying and litigating that has the potential to cause problems. In litigation, what matters is your credibility. 100%, there's nothing else. That's the beginning and the end of it. The judges have to know that they can trust you. So when you tell them the law is this, that is actually going to be the answer. Policy arguments are interesting, they're influential, but it's legal arguments that carry the day. Judges do accept that interest groups are going to litigate, and some of them are going to be right. but you have to make concessions in litigation that electoral politics don't allow. If a judge sees a lawyer as a politician, that lawyer is going to lose. Now, this is a problem, I think, for the NRA. The NRA is an excellent, well-known political lobby. It will always be seen as the gun lobby. It's earned that right, and thank God for it. Great stuff. However, the NRA needs to seriously consider in the future whether it makes sense for it to litigate under its own name, if only because it may be put in positions where it has to concede that policies it opposes are, even though they are bad policies, nonetheless constitutional. I know it is easy to say everything we dislike is unconstitutional, but that really is limiting in a courtroom. Now, the most dangerous difference between litigation and politicking, and I've alluded to this earlier in my comments, is that in lobbying, if at first you don't succeed, you try again, right? You can always come back in the next session. You can always try again, perhaps after an election, perhaps after you cut some kind of a deal. Litigation does not work that way. In litigation, if you lose, you might set bad precedent. You might not come back. If you set bad precedent in one issue, it will contain language that may or may not kill you on another issue that you could have won had you only done the things in the other order. Politics, after all, is about getting a one-word answer out of a politician, yay or nay. The political motivations behind these votes don't matter in the end after they're tabulated. Law works differently. What matters in a judicial precedent is the reasoning, not the result. So winning begets winning, and losing begets losing. A careful strategy is one in which cases are done in the right order. Our goal is to make the Second Amendment a normal part of the Constitution. What does this mean? It means that it becomes non-controversial in the legal sense. It means that everyone accepts it. If the Second Amendment becomes a hobby horse for right-wing people, it will be unstable as far as the law is concerned, and it will always be subject to attack. We have to make the other side accept the premise of gun rights. Even if they don't like the policy, they have to at least concede its constitutionality. That's something that's very important for us to do in the law. That's very different than what happens perhaps on Capitol Hill. Barbara Boxer and Chuck Schumer are never going to be A-rated. They disagree with us. They're always going to vote the wrong way on gun votes. That's just in their DNA. In McDonald, we got the New York Times editorial board to endorse applying Second Amendment rights to the states. Okay? We actually had an editorial supporting us in the New York Times. Amazing. And it's not because the New York Times is pro-gun. Okay? We got very liberal constitutional scholars to support us. Interesting progressive groups to come out and support us. And we didn't do this by claiming that guns are extra special and therefore are entitled to protection as a matter of what's called substantive due process. I'll get into that in a moment. No, we got that a different way, the old-fashioned way. We argued that the text of the Constitution, as originally understood by the people who ratified it, compels states to honor the right to keep and bear arms. Who could disagree with that? Well, that mode of argument usually appeals to conservatives who believe in applying the written Constitution. But here it also appeals to liberals who correctly understand that the 14th Amendment secures national civil rights standards. They're willing to accept the Second Amendment as part of the civil rights bargain. Why not let them make that deal? That is the mode of argument that is sort of the one that people point to as a slam dunk. It's the mode of argument that traditionally has been less appealing to conservatives who don't want to hear about the idea that due process contains emanations and penumbras and weird substantive things that aren't there. They want to look at the written text. Well, the written text of the 14th Amendment starts out by telling you that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That's pretty clear. It's clear today. It was very clear in 1868. And so that's the argument that we led with because it's correct, but not just because it's correct, it also happens to appeal to a wider group of people. And it brought us non-traditional allies that were very useful. Not everybody saw it that way. The NRA, having failed to get its case accepted by the court, saw our attempt to provide greater security for gun rights as their opportunity to reduce this very important Supreme Court argument into a fundraising gimmick for them. They hired the former Solicitor General of the United States, the one who opposed us in Heller, to insert them into the argument, claiming that we were spending too much time actually discussing the actual text of the Constitution. So what a strange way to win, to attack your side's preparation of the case and whittle down the argument time. I suspect they did this probably because they believe the case was won anyway, so they might as well try to take the credit for it, even at the risk of damaging some of our arguments that might appeal to people who otherwise would not be brought into it. It is difficult enough to have a cogent conversation with 9 people in the Supreme Court about some of these very important issues in only half an hour. The compression of that time into 20 minutes, for me, with a 10-minute soliloquy on an issue that frankly is not very difficult, was not helpful to the cause. And there you have it. But right now, having encapsulated some of the problems that I see in the future, what do we need to do? Well, first of all, I will keep bringing cases. With the wonderful support of Alan Gottlieb and the Second Amendment Foundation, we have a fantastic litigation program going forward. We are fighting all kinds of ridiculous gun laws. We will probably fight some more. I will also keep supporting other people who have litigation. Of course, I don't pretend that I can monopolize the field. That would be ridiculous. I don't have that much time. I'm also not that interested in doing everything. I don't need to control everything. And so when people come to me for help, I will continue filing amicus briefs. We will continue to try to support our friends. When other lawyers come to me with serious cases where there are serious problems, if there's something I can do to help them, I will do that, and I'm sure that staff will be there with me 100% of the way. We're going to do our part. The question is, will the NRA do its part? And what I suggest to you as members or people who may have the ear of someone out there, because I sure don't, the first and foremost the problem is with ILA, okay? Like I said, there are many wonderful people at the NRA who are great, and they get this, but the litigation seems to be controlled by the lobbyists who are approaching this as a lobbying venture, a fundraising venture, a brand extension venture. Those are all the wrong values to bring to the table. The lobbyists should not be running litigation. It's not among their skill sets. Litigation is for lawyers. Okay. The second thing I think they should do is stop trying to own everything. Okay, my copy of the Second Amendment does not have a little copyright NRA ILA symbol on it. Okay, all this crazy controlling weird behavior, it's not healthy. Okay, it should probably, end. Our resources are not unlimited, neither ours or the NRA's, and they should be spent trying to advance gun rights, not obsessing over controlling and branding and excluding people. If the NRA wants to litigate, and perhaps it should, and I would welcome that. I would welcome that. They need to also then get some civil rights professionals. I'm not offering my services. We're beyond that point. This will require a search committee. They should not do what a lot of corporate type organizations do and just look for a place to throw away all their money on some large firm. Those places have their unique advantages. They also have unique disadvantages. And when you look out at strategic civil rights litigation being done on other issues and other fields, you typically don't see a lot of participation by big firms. It's simply not, again, really within their skill set. We need to look for real people with real strategic civil rights background. Look at all the other issue groups historically that advance political causes or constitutional issues. The ACLU, the NAACP on the left, and on the right things like the Institute for Justice or Pacific Legal Foundation. These people know what they're doing. They bring a certain body of knowledge and expertise, and that's really what we should look for. You need a strategy and a vision implemented by people who know the strategic civil rights litigation business. At least that's what I'm doing and what I will continue to do with SAF. And I would very much welcome the NRA as a useful professional participant instead of whatever it is that they're doing these days, which is really not that clear to me. So with that, I will let the evening proceed, and I look forward to addressing as many questions and answers as we've got this room for. Thank you so much.